Good morning. We're on the record. Let me call to order the City Board of Ethics and Campaign Practices. We have one major item on today's agenda, but let's take care of a few other items first. We have the agenda for the meeting of Monday, January 29th, 2018. Can I have a motion to approve today's agenda?
I'll move to approve, Mr. Chairman.
Okay, we'll get everybody going here. Is there a second to that motion?
I'll second.
Okay, is there any objection? All right, the agenda for today's meeting is approved. In our packets, we also have the minutes from our last meeting of December 19th, 2017. Those were already circulated to all the members of the board. Can I get a motion to approve those minutes?
I move that we approve the minutes.
Okay, is there a second?
I'll second.
Any objection to that? All right, then the minutes from the December 19th, 2017 meeting will be approved. Let's move to the one item we have for board action today, which is the evidentiary hearing in Board of Ethics 11-2017, Carlos McMahon versus Tim Keller and Javier Benavides. Before we get going, let me just make a couple of comments about what will and will not happen at today's hearing. The evidentiary hearing that we're about to have is governed by the rules and regulations of this board, specifically Section 6, Article H. Our purpose for being here today is to provide the parties with an opportunity for a full and a fair hearing. But I want to stress that full and fair hearing does not mean an unlimited amount of time for the parties to plead their case. As chair, the rules expressly empower me to impose reasonable limits on the number of witnesses to be heard and the nature and the length of their testimony. The parties will have an opportunity to present oral or documentary evidence and argument in all issues. The only constraint on that is that the evidence and the argument presented cannot be on irrelevant, immaterial, and unduly repetitious issues. The evidence must have a direct and substantial bearing on the case. Let me also talk just a moment about the powers that our board has following today's hearing. Under Section 6, Article I, the powers of this board are limited and constrained. We can impose fines of up to $500 for each violation of the election code. We cannot rule on the validity or constitutionality of the election code. We cannot remove any person from elected office. Now, let me specifically remind council, in particular, about the amended order regarding the conduct of the evidentiary hearing, which the board entered on January 12th, 2018, and specifically the first paragraph. This is the amended order, which was in response to a motion from the complainant to enlarge the time for today's hearing. What the board has ordered is as follows. The evidentiary hearing shall be held for a total of 120 minutes from 9 a.m. until 11 a.m. on January 29th, 2018. The time shall be divided equally between complainant and respondent. During their allotted time, each party will be afforded an opportunity to make opening and closing statements and to present evidence in support of their respective positions in the form of witness testimony, documents, and recordings. So under this order, each side will be given 60 minutes in which to present their case. I will keep the time, and the time will be strictly enforced. Complainant will present his case first. Respondent will be given the opportunity to cross-examine any witnesses as they are presented. Cross-examination time goes against the attorney who is using it. The board will also be given the opportunity to ask questions of any witness. Respondent will then present their case in a similar manner, and depending on the time and the discretion of the chair, a rebuttal case may be allowed. Again, depending on the time permitted, each side will have the opportunity for closing statements. The board is then going to adjourn into closed session. Any decision of this board is required to consist of a written statement of facts and findings from the board. Now, before we begin, let me ask for an entry of appearance. Who is here on behalf of the complainant?
Good morning, Mr. Chairman, members of the board. Larry Dunn on behalf of Carlos McMahon, the complainant.
Okay, and for the respondents?
Good morning, Mr. Chairman and members of the board. Molly Schmidt-Nowara and David Udias on behalf of Mayor Tim Keller.
Okay, and is anyone here representing respondent Benavides, or will he be representing himself?
Good morning, board members, Mr. Chair. I'm Ed Benavides representing myself.
All right. Now, I understand before today's hearing, we learned that Mr. McMahon, unfortunately, is not able to be with us today because of a health issue. And council have had the opportunity to confer. It's my understanding that both sides, despite Mr. McMahon's absence, are willing to go forward today. Mr. Dunn, is that correct?
That is correct.
And for the respondents?
That is correct.
Okay, Mr. Benavides? All right, then we will be able to get going. So, I'm starting the clock, so we will, the first order, oh, let me mention one other matter before we get going. Late Friday afternoon, I understand that Respondent Keller filed a motion to quash subpoenas seeking testimony from his attorneys and supporting memorandum. This was circulated to the members of the board earlier this morning. This is how I propose that we deal with that motion. I'm going to table that motion for the time being. Mr. Blair, what I'm going to suggest is that you present your case with all other testimony and evidence other than the proposed testimony of the lawyers. After you've presented your case, if you still feel that you need to call those lawyers, what I'm going to do is I'm going to first ask for a proffer from you as to what that testimony will be. At that point, I'll allow the respondents an opportunity to decide. We'll see if, in fact, at that point, the motion will be granted. So, in essence, I'm going to hold it in abeyance, see if we can avoid it. If we can't, we'll rule on it, but I'd like to push that to the end rather than take our time at the beginning. Is that understood by both sides?
Yes, sir.
All right. In that case, the floor is yours.
Mr. Chair, members of the committee, and I would like to address that as part of my opening remarks. I think that'll lay some foundation why it will be acceptable to call the lawyers, and for the limited purposes that we're trying, it will be very short that we get to them. So if I could, I'd like to go through some opening remarks. I'll touch on that subject at this time.
What I will tell you, the floor is yours, so how you wish to spend your time is completely up to you.
Well, following closely on what you've said, I'd like to go ahead and address the reason for the request to have the lawyers appear and testify. The reason that they would be appearing is for a very limited purpose, and that is to just address their hourly rate. And I'll use an example as to why that's relevant and important for this board to consider. The Elections Code does address in-kind donations for professional services such as lawyers. It addresses that they should be done at the general market rate for that attorney. The only reason I would be calling the attorneys is to see what their normal market rate is. Now, the reason that's important is, let's say, for instance, that Mr. Urias has an hourly rate that shows up on the evidence that was presented to us of $225 for these invoices. His normal hourly rate may be something greater. So that if his normal hourly rate is $300 an hour and he's given this out at a discount to $225, there's a benefit to that discount, which goes to the benefit of the candidates and their campaigns. So it's important for us to know, and for this board to know, what that discount is, because that is, in effect, an in-kind donation by those lawyers. That's the reason for calling them up, is to see what their normal hourly rate is, so that this board consider whether or not there has been a donation of an in-kind professional services that was not on the campaign disclosure forms. So that is the reason that we've asked for those attorneys to be here, so that we can address those two concerns. And I believe with very short testimony from both Mr. Urias and Mrs. Molly Schmidt-Nowara, I think we can nail that down fairly quickly for the board, and I don't plan to take a long time with that. So that's one item to put the pin in, as the chair has indicated at the table, to come back to. But I will go ahead and lay the foundation for the rest of this morning as to what's important. I intend to call Mr. Benavides first, and then I intend to call Mayor Keller after that, and have them testify about how they paid for this. So what we're really talking about today, and based upon the proffers of evidence for exhibits that we did see from the respondents, We understand that the campaign did not pay for these lawyers to defend these candidates in these proceedings here in front of this board. And I want to emphasize, I emphasized this at the last hearing of this board, why that's important is we are not here to address Mr. Keller's personal capacity, nor Mr. Benavidez' personal capacity. This board is convened with authority over regulation and the conduct of elections. It's the candidate that we're addressing here. When they appeared before this board previously with attorneys, it was in defense of their candidacies. We're not here because they let their dog off the leash and it bit someone. We're here because of campaign finance violations. That's ultimately what was addressed, and this board has already addressed one of those violations, or two of those violations by each of those individuals. That's why we're here. They had attorneys that helped with that. Now, Mr. Benavidez, in his statement of his brief of legal authorities, makes a good point. And I can't help but concede that he's got a valid point as to the concern that if there are a bunch of frivolous complaints filed, that candidates end up using up campaign resources, their public financing money, for dealing with frivolous complaints. But as I offered to you last time, this isn't the board that would change those rules. This is a board that might recommend changes to those rules, and this is certainly a board that can deal with violations of the rules. So there may be a very good point to his brief, that there may be something that needs to be changed in the rules. But this isn't where we change the rules. And until the rules are changed, this board is to enforce the rules, and the candidates are supposed to follow the rules. The fact that it may not be fair is not, and should not be, persuasive to this board. So as to the idea that attorney's fees have been racked up by a campaign, and it wouldn't be fair to make the campaign pay for those, like I said, he's got a point, but I don't think that this is the avenue to address that. I will also note that he did file his brief after the deadline, showing yet again a failure to grasp the gravity of needing to follow the rules. Your order clearly said 5 p.m. He turned them in at well after that. I think it was close to 9. That's not the way this is supposed to work. We're supposed to follow the rules. We want candidates to follow the rules, especially if they're going to be using public money. That is the reason for public financing, and there's a public trust that attaches to that public financing. And when they don't follow the rules, the public loses that trust, and that is important for the conduct of our city elections and important for the conduct of the city, that we have a mayor that we can trust in, that he will follow the law and the rules, or we have city councilors that will. If they can't follow the rules during an election, what's to expect that they're going to follow the rules during their time in office? Let's see. One of the other important points that we would probably concede is that since the disclosures that were made, the affidavits from the law firms, from the administrators in the law firms, plus the affidavit of Ms. Hunt, who was the campaign manager for Mayor Keller, indicates that there was no use of funds from the campaign, and further indicates that according to the affidavits that were presented, that Mayor Keller and Mr. Benavidez paid for these services out of their pocket. That raises an interesting concern beyond just the idea that there is that there's a concern that they are not disclosing the use of those attorneys for the candidacy, the professional capacity question, but rather that there may be an attempt to sidestep the rules here. And I'll give you a hypothetical. Let's say, for instance, candidate A goes out, he ends up being sued, he goes out and he retains lawyers. He says, I'm going to pay you in my personal capacity to do this. I'm not going to use campaign funds for this. Now, one, there's a problem because the most that's allowed under the rules is $500. It's not going to buy you a whole lot of legal fees, because if I take $500 out of my pocket as a candidate and give it to the lawyer to defend me, that's all I can give to the benefit of my campaign under your rules. That's about maybe 2 hours worth of time for one lawyer. That doesn't get you where we are today, which we see from the affidavits is tens of thousands of dollars spent on lawyers. So let's say, how do you address this? I'm the candidate, and let's say, for instance, I've racked up a bill of $60,000. I don't have the money personally to shell out $60,000 for an attorney in the midst of a campaign. So how do I, in my personal capacity, pay for that? And this is why this is important. This is why the evidence today you'll need to consider is very important. Let's say, for instance, I'm popular with the labor unions as a candidate. They turn around and they say, well, we really want you to be mayor. You're being sued in front of this board for failure to follow the campaign finance laws. So we'll help you out. We'll go ahead and we'll give you the money, you put it in your account, and then you take it out of your pocket and you pay for these attorneys to help you become the mayor of Albuquerque. For instance, SEIU gives you $60,000 towards attorney's fees. That is to the benefit of the campaign. That's a donation or a contribution to the campaign for the benefit of the candidate. Now, it may have been traced through his pocket, but it is still ultimately a contribution to the campaign in excess of what is allowed under your rules. And that's why we're here today, is that very clearly a lot of money has been spent on attorneys that is unaccounted for, and we need to see the evidence to see where that came from and see if it does actually violate the rules of this board and of the city election code for Albuquerque. One clarification to what you said, Mr. Chair, in that this board can fine the individuals. This board can also require that a candidate comply with the election code, and I would point the board to election code section 6. If there has been an overage, this board can also require that those monies that were in overage of the amounts allowable has to be paid back into the public coffers. So I really wish my client was able to be here and explain. The reason he's pursuing this is because that public financing has a public trust attached to it, and they violated that public trust. The remedy that this board can order is to have that money paid back in and for these candidates to follow the election code. So whatever money has been spent through whatever chain of personal pockets, that money needs to go back into the election code in order to restore the public trust in campaign financing. So with that, I would go ahead and call Mr. Benavides to the stand.
Sorry, yes.
We would like to give an opening statement if we could.
Yes, and
Sorry,
they'll be
I
permitted to do
apologize.
it. Not a problem, not a problem.
Good morning, Mr. Chair and members of the board. Good morning again. This case is simple. It's a simple deliberation for this board today. And that is that this complaint should be, the result should be that this complaint should be dismissed in its entirety. Mr. Dunn has admitted in his opening statement that the basis for the complaint, the allegations in the original complaint filed by Carlos McMahon, were baseless. Fishing expeditions and pure speculation that have resulted in, after evidence has been presented, in showing that they were baseless allegations. In fact, the uncontroverted evidence is that Mayor Keller did not use any public funds to pay for his attorneys. In fact, the uncontroverted evidence shows that Mayor Keller's attorneys did not volunteer their services, thereby invoking the in-kind contributions provisions of the charter. So, having abandoned those complaints, those allegations, Mr. McMahon has now moved on to a third theory, which is equally frivolous. And that is that, in essence, two. One, that some phantom third party has assisted paying Mayor Keller's attorney's fees. Again, there's no evidence to suggest that, and that is untrue. And the evidence today will show that. And finally, that even if Mayor Keller simply used his own personal funds, that he is not allowed to do so under the charter because he can only contribute up to $500 of his own funds to his campaign. That argument falls apart on a closer reading of the charter and the amendments to the charter. First of all, the provisions that Mr. Dunn cited to in his legal brief apply just to seed money, just to the seed money contributions that candidates can make under 3G and Section 6. They have nothing to do with attorney's fees, ethics boards, complaints, or anything like that. And in fact, the relevant portion that the board should look at is under Section 6 I-11, which is a provision that the Mr. Chair discussed, talking about the powers that the board has if the board finds that there is a violation. And Section 6I-11 states clearly that if this board finds a candidate or an individual who has been brought before this board on an ethics violation complaint, that individual cannot use campaign funds, public money, any campaign-related funds to pay that fine. They're individually responsible for those fines. So the natural, necessary, and logical corollary to that is that if an individual, as Mayor Keller was when he was still Mr. Keller, State Auditor Keller, I guess at that time, is accused by an individual of ethics violations, that they have the right to decide to use their own money to make themselves responsible to pay for attorneys. Now, Mayor Keller could have done one of several things. He could have used public monies and reported that. He could have hired lawyers that volunteered their services and then reported that as in-kind contributions. Or, as he did, he could personally make himself responsible for those fees, and that's what he chose to do, and he has a right to do that. And there's nothing in the charter that obviates that right. If the board accepted the complainant's theory here, final theory, this sort of in this moving target of allegations, what they finally landed on, then it would lead to two absurd results. One would be that it would embolden frivolous claims against publicly financed candidates, because those candidates would be in an impossible catch-22 situation. They would either have to represent themselves pro se, or they would have to allocate significant funds from those public monies rather than spending them on their candidacy, or they would have to find lawyers who would volunteer their services, thereby eating into the in-kind contributions portion that they have a right to under the charter, or they would have to find some other way of financing it, but only up to $500. So it would lead to a completely ludicrous result that would embolden these frivolous and baseless allegations. So we ask that this board, once and for all, shut this down and send a message that frivolous, baseless fishing expedition complaints cannot and should not be filed, that this board is not a political tool. This board has an important job to consider whether individuals are in compliance with the Code of Ethics. This board should not be weaponized to essentially run aground the public finance system. We'll ask at the end of this hearing, again, that this board dismiss this complaint in its entirety. Thank you. I will say this, my co-counsel, learned co-counsel, raised this, and I think this is true. I would submit to this board that the board could dismiss this complaint now. The two bases for the complaint that went forward at the preliminary hearing back in December were, one, that Mayor Keller and Javier Benavidez used public money and failed to report it, or in the alternative that their lawyers volunteered their services. Mr. Dunn has conceded that neither of those bases are true, that the uncontroverted evidence that we have submitted in response negates those allegations. So I actually think I agree with Mr. Urias that there is a basis for this board to just dismiss this complaint at this time and let's be done with it. And I would submit that also would actually send the right message, which is that, again, individuals can't submit frivolous complaints. Given that the preliminary hearing standard is so low, the board is somewhat handcuffed in letting complaints go forward. But now here we are at the evidentiary hearing, and the complainant has conceded that the bases for the complaint are frivolous, that there is no basis actually for the complaint. So I would ask that the board seriously consider dismissing the complaint at this time.
Mr. Benavidez, do you have anything to add?
No, I'd like to waive my right.
Mr. Dunn, the floor is yours for your first witness.
We'd call Mr. Benavides to the stand. And while he's getting sworn in, if I could, just a quick rebuttal. The idea that we've conceded every argument is completely belied by the point that I discussed as to why the attorneys need to testify. There is an in-kind contribution that they failed to report. If their hourly rate that they gave these guys is such, and it's less than what they normally charge. So the idea that we've waived that argument is just completely erroneous. So,
Before you begin, Mr. Benavides, good morning. Could I ask you to raise your right hand? Do you swear that the testimony you're about to give will be the truth?
Yes.
Thank you. And can we ask you to speak into the microphone?
Yes, certainly.
Thank you.
good morning, Mr. Benavides. How are you today?
Doing well, thank you. Good morning.
I have an exhibit that I'd like to hand out that was the one exhibit that didn't cause a whole bunch of email problems, and I apologize to the boards.
Thank you.
We had attached basically all of the campaign finance reports for these individuals. I didn't think you guys really needed 8 stacks of paper this much, so bearing in mind the admission that there was no conceivable way to really get that done without a huge cost to a citizen client that's already putting out of himself.
Did you provide a copy of this for opposing
I did
counsel?
provide them a copy, yes.
Okay.
I'll explain what it is. It's the affidavit of, or the exhibit regarding Mr. Maez, affidavit of Dennis Maez.
Well, do you have an extra copy for opposing counsel?
I do.
That'd be great.
Mr. Benavides, the first thing I'd like to touch on is a gentleman by the name of Dennis Maez. Do you know who he is?
Yes,
Have you ever retained his services
yes, as part of this case, or the previous case.
as part of the previous case? How was he paid?
My understanding is that it was wrapped into the bill that I received from Molly Schmidt-Noor and her law firm.
What kind of work did you understand that he was to perform?
He was doing research for our case, providing another opinion to interviewing the people who were alleged to have committed fraud. Or he went around and followed in Mr. Villanueva's footsteps, basically.
So he was working in aid of your candidacy, is that correct?
He was working in defense of the complaint that was filed against me.
And that complaint was filed against you as a candidate, is that correct, that you were not following campaign finance laws?
That's a gray area of whether it was against me as a candidate or me as myself. I retained legal services because I was very concerned about Mr. Rogers and the charges that were being brought against me and my reputation.
You called it a gray area. Could you give us some more explanation of why that's a gray area?
I think it gets down to the brass knuckles of public financing. As a candidate, myself and the incumbent and everybody else who qualified for public financing receives $1 per constituent, per voter in your district. That was $38,000, roughly, for District 1, and the total of my attorney bills is $43,000. So I actually wouldn't have been able to run as a candidate under public financing had we used public financing to defend against this case.
Okay, and the $43,000, that includes Mr. Maez's work, is that what I
Correct.
understand you're saying? Okay.
Correct.
So, what's your understanding of the amount that of money that a candidate can contribute to their own campaign under the public financing laws?
It's $500,
That's the maximum,
yes, and I did that.
okay? And you said you paid $43,000 for your attorney's fees?
The case is still in appeal in the district court now, so I won't be responsible for paying that amount until the case is finished.
Okay. And you paid that out of your own pocket?
I plan to,
You plan to?
yes.
Okay. Do you see any issues with the fact that you're going to pay out of your pocket something to the benefit of your campaign? Does it bother you?
That's an interesting question because I would flip the premise. So what happens when candidates are assigned or are accused of frivolous complaints and someone like Pat Rogers or Mr. McMahon himself can file unlimited numbers of complaints to this ethics board, and candidates are responsible for defending themselves. Pat Rogers is a pretty powerful attorney with significant interest behind him. It makes sense to bring in enough support to defend against that.
Mr. Rogers enjoys a pretty good reputation as an attorney, as a tough attorney, correct?
Correct.
Have you heard any sort of allegations that he stands behind frivolous complaints normally?
There have been lots of media coverage about the complaints that he's that have been questionable. I think of the one back in 2008 when he accused, I think, 40 or 50 naturalized citizens of voting illegally, and encouraged the U.S. attorney to investigate that, and it became a big question because I think Senator Domenici weighed in on that, or Heather Wilson, Congresswoman Heather Wilson at the time, and it backfired on him because they were very frivolous complaints.
So if a candidate violates the campaign finance laws, do you think that that really classifies as a frivolous complaint?
I think that's the subject for this ethics board to consider that a lot of these complaints come from people who are politically aligned in opposition to you. The exact same issues existed in my opponent, the incumbent's public financing qualification, but he was not the one who was targeted because he was much more aligned politically with Mr. Rogers.
Did you report, let me ask, so you knew of violations by your incumbent opponent, is that correct?
Through our investigation with Mr. Maez, yes.
Did you report those to this board?
I thought long and hard about that. I was encouraged by my campaign consultant to do so, but whether that's the kind of politics we want to devolve into in this city, I just didn't feel like it was right.
So if it's not right, do you think it's frivolous?
I just, I think it probably cost me the election. It cost me getting into the runoff that I didn't file that charge, but at the same time, I didn't feel like subjecting somebody to that level of dirty politics. I didn't feel like I needed to, finding one of my constituents to file one of those charges, having them have to go through this entire process publicly, it just didn't seem right to me. It wasn't worth winning the election for that.
I'm going to back up. I think what I understand you to be saying is that the motivations of the person are more important when deciding whether it's frivolous than the actual point of whether it's a violation. Is that what you're saying?
I'm going to object. I think this is getting into totally irrelevant issues. I think the issues before the board are pretty clear and were outlined in both opening statements, and now we're talking about a prior board hearing and whether Pat Rogers brought a frivolous complaint. I don't think that's before the board today. Mr. Benavides has not filed a complaint against Mr. Rogers.
Well, what I am going to suggest is this is starting to get very repetitious. So with the objection in mind, I'm going to urge you to move along.
I would like an answer to the last question. If
That's fine, and then I'm going to urge you to move along.
Thank you, sir.
Could you repeat the question, please?
It's your testimony here that when it comes to deciding what's a frivolous complaint, goes more to the motivations or the political alignment of the individual making the complaint rather than whether it's an actual violation. Is that what you're saying?
I think you have to look at the specifics of the case, and there was a lot of gray area in the city ordinance about how public financing could be collected, whether a husband can sign for a wife or a family member for the other. And those are basically the problems that they identified, and I know that many of those problems existed in my opponent's campaign finance report too. So if I guess that's, Pat Rogers has found a fantastic niche, and Carlos McMahon too, where they file these kinds of ethics complaints against their opponents, and it basically affects the election. And I would flip the question back on you: is why weren't they reporting their contributions to the incumbent's campaign? Because they absolutely helped his cause. I mean, Santa Elena Political Action Committee came in and put out billboards and did hit pieces on me as a result of these ethics complaints.
I'm not quite sure about, first of all, I don't have to answer your questions. You'll understand that. I'm not on the stand, you are. But I'm not quite sure that I understand the premise of your answer. You're saying that there's been a violation by Mr. Rogers and Mr. Villanueva, and that somehow negates whether or not you've had a campaign violation. Is that what you're saying?
I'm saying that they found a niche within city policy to accuse people, innocent folks like myself, of violations, and then use that for their political purposes. And I would expect this to continue in every election cycle going forward, unless this ethics board is able to somehow get a handle on this all.
Okay. last question, if you violated campaign finance laws, are you innocent?
I take responsibility for the mistakes that some volunteers made. I take responsibility for not being clearer with the directions, but I don't think there was any ill intention. They were honest mistakes, and if I were to do this all over again, it would be a much different process.
I know, I said one last question. Has anybody contributed to you personally, given you a check or promised you a check for money to pay for attorney's fees?
Absolutely not.
Yes. I know you'd like to sit down, but I need you to stay put for a minute. Cross-examination.
Thank you, Chair. Mr. Chair. Mr. Benavides, I just have a couple of questions for you because I think we pretty much covered it all there with Mr. Dunn's questions. But just to be clear, you are aware of the complaint, the current complaint brought by Mr. McMahon against you, correct?
Yes.
All right. And you understand that he is alleging that you use public finance money, or at least he initially alleged, that you use public finance money to pay for your attorneys in the ethics complaint that was brought previously. You understand that?
Yes.
Did you use public finance money to pay for your attorneys?
No.
All right. Did the attorneys who you retained volunteer their legal services?
No.
Do you have an agreement with the attorneys to pay them at an hourly rate for the work that they performed both in the prior proceedings and on appeal of those proceedings today?
Yes.
That's all I have. Thank you. Thank you, Mr. Benavides.
Is there any redirect?
Just a very short one. Mr. Benavides, you agreed to an hourly rate for your attorneys. Were you told we'll give you a discount?
No.
Okay. No further questions for this witness.
All right. You may step down. Thank you, sir. You may call your next witness.
Mayor Keller, please.
Mayor, good morning. Could I ask you to raise your hand, please? Right hand. Do you swear the testimony you're about to give will be the truth?
Yes.
Thank you, sir. You may proceed.
Thank you, Mr. Chair. Morning, Mayor. How are you?
Good.
You heard the questions from Mr. Benavides just now. These are going to be similar, and I bet we can get through them even faster with you than we did with him. What's your understanding of how much money you can personally contribute to your campaign?
My understanding is $500. I think the irony is that's even seed money, which then gets counted against you. So net, it's actually zero, but that's the mechanics.
Are you aware of any provision that allows you later to contribute money to your own campaign?
No.
No. The election code is clear that there is that amount limited to the candidate that they can give in cash or in kind to the benefit of their campaign, correct?
Yes, again, that's part of the seed money provision.
So let's talk about your attorneys. You've had attorneys appear here today, and I'm sure the board can make note of the fact that these attorneys are here again with you. How much money have you personally paid to these attorneys?
I haven't personally paid yet, so I know I owe them based on their invoices.
Do you know how much you owe them?
You know, I saw the two bills, which keep getting bigger because there keeps being more complaints filed. And so I think if I added them up, it was around $30,000.
For all of these proceedings?
Again, my looking at those, I mean, I have it all in paper, and so does the board. So, but yeah, that was what I recall.
What was the hourly rate that you agreed to pay these attorneys?
They have a standard rate, and it's whatever they listed in those invoices. We never had a discussion about a specific dollar amount.
And you're going to have no problem paying off the $30,000 plus of attorney's fees that you have?
I'm going to object. One, I think this is getting into attorney-client privilege, and two, whatever whether there is a fee dispute or maybe a fee dispute or not a fee dispute or anything like that is not relevant to these proceedings or these allegations. And so I'm certainly going to instruct my client not to answer anything that would invade the attorney-client privilege.
That
And
instruction, do you have a response to the objection?
I have no problem with that objection. I'm not going to be asking about attorney-client information. I'm inquiring into his personal financial situation.
Well, I don't believe ability to pay is one of the issues that we need to consider, so the objection will be sustained.
Thank you.
Mayor Keller, could you explain your decision to pay for your attorneys out of your personal finances?
Well, the complaint, even on its face, is against me as a person. As we've discussed at length in other hearings, there are different entities involved, meaning a campaign, a person, et cetera. And so, to me, one, the complaint is against Tim Keller. So, and I've known from my work as auditor and then even in the state legislature, when individuals represent themselves and they hire attorneys, they pay for the attorneys.
Mayor Keller, you understand that the reason for these complaints is for violations of election code, is that correct?
I understand that's the face value reason. You know, I think we all know what the real reason is here. I mean, these are politically motivated to affect elections. And I mean, you're even running for attorney general. And you've stated in your statement that part of the reason you're running is because I've committed 3 felonies: criminal fraud, money laundering, and conspiracy. And this board explicitly disagreed with that in the last hearing. So yes, I think there are all sorts of reasons for these. I also think how you're getting paid and how the other attorneys are getting paid is just as important. You know, Santolina, as the last witness mentioned, they are clearly involved in elections, and if we are going to talk about how we're paying attorneys' fees, the opposite has to be true too. Who's funding all of these lawyers who are then filing the ethics complaints, and who are their clients, and who are their conflicts? That's what this is about. That's what it's always been about.
So Mayor Keller, let me ask you this. If your citizen watchdog is concerned that you're not following campaign finance laws, they come to an attorney like me, obviously politically motivated. I have no problem admitting that. But I'm willing to do it pro bono. You're saying that that citizen who comes to me and asks for me to do pro bono work for them is subject to the same scrutiny that you are as a candidate?
No, I'm not saying that at all.
Then please explain what you're saying, because you're talking about your personal capacity. I think you're really talking about your candidacy capacity. And now you're saying that the average citizen off the street should be subjected to this board in their personal capacity because they participate in a watchdog fashion with their government.
It's not at all what I said.
Your understanding is $30,000. Is that correct? Or roughly?
Mm-hmm. Yes.
None of that was paid from your campaign finance money.
0.
You don't understand that there was any discount at any rate for your attorneys such that there is a benefit to your campaign in having these attorneys defend you?
None.
And you don't think that the motivations of the person that wants to complain about you not following campaign finance laws is relevant? Or is irrelevant? I'm sorry.
You'd have to restate that one. There was like 2 negatives in there. I don't understand.
That's fair. It was a double negative. I'll rephrase the question. Do you think it's fair to say that the political motivations of a citizen that's concerned that you're not following campaign finance laws when you take public money are irrelevant?
I'm not even sure why that question is relevant.
Well, so you're saying it is relevant that a citizen has political motivations when they're concerned you're not following the law?
Well, anyone's motivations are always part of considerations, and I think I spoke to very specific situations with specific representation and made no comment on the public at large.
So you're saying that the intent matters more than the violation?
No,
Do you think the violations matter?
any violation always matters relative to the strength or severity of its violation.
So if it's a fairly severe violation, for instance, a candidate illegally takes in $50,000 in campaign contributions, is that a frivolous complaint?
I'm going to object
Let the
now.
board
Hold on one
decide.
second. Thank you, Mayor.
Thank you.
There's a objection.
I'm going to object to this line of questioning at this point is getting irrelevant and quite far afield of what we are here for today. I've been patient in allowing this to go forward for some period of time, but I think at this point, I would ask that the board instruct Mr. Dunn to move on.
I am going to make the same ruling. This is starting to get frivolous, so I'm going to urge you to move along.
Mayor Keller, what were your motivations in hiring attorneys to help you defend against actions in front of this board?
They were to help me defend actions in front of this board.
Was it so that you had a chance to become mayor of Albuquerque?
No, they were to help me defend actions against this board.
So you don't think it was an aid of your campaign at all to explain to this board why you hadn't violated campaign finance laws?
Directly, no. And in fact, I think as we saw in the media, it was in effect the opposite.
Can you explain that? I'm not quite sure I understand. What was in opposite about this not being in aid of your campaign?
Well, we all know that when we're in the public spotlight, which any complainant is, and so is the recipient of that complainant, that it impacts things and how people might feel for good or bad or in any direction. And so I think the notion that somehow you can completely say that there's no one impacting the other, but I do know that the complaints were made against me as a person and against the comments, for example, that you stated about felonies and so forth. So I would defend myself regardless if anyone says that about me, because it's not true.
Do you understand how this board has jurisdiction over requiring you to be here today?
Yes, I think so. And I'm happy to be here at their request.
Did this have anything to do with, for instance, you violating some sort of sidewalk ordinance?
No?
Is it a civil matter? Somebody is suing you in district court?
Excuse me, there's an objection.
I'm going to object. This is again becoming irrelevant. Mayor Keller has testified. He understands why he's here and this board's jurisdiction over him.
Your Honor, if I might.
Yeah, please.
The argument is that Mayor Keller and Mr. Benavidez paid for this out of their personal capacities. What is clear is we are not here on a personal matter today. We are here because you're a board of ethics. It is entirely relevant to understand whether or not what his understanding of personal capacity is to determine whether or not that's even a valid thing. And I think it is helpful to this board to hear from the mayor his understanding of how he paid for this.
Well, for better or for worse, the candidate's understanding is not what we go by. What we are required to do is enforce the language of the code, and there's nothing in here about subjective intent. So I'm going to sustain the objection.
Okay. No further questions.
Very briefly, thank you. Mayor Keller, you testified to this, but just to clarify, the complaint brought against you regarding in-kind donations was against you as an individual, correct?
Yes.
And if you had lost in the general election in October, we had an evidentiary hearing set in November, correct?
Yes.
And that hearing would have, your understanding is that hearing would have gone forward against you regardless of whether you were a candidate, right?
Yes, and I think, unfortunately, Mr. Benavidez is a great example of that.
And if you had been fined by this board, your understanding is you would have had to pay for that yourself, right?
Yes,
Not your campaign.
correct.
Now, did you use any public monies to pay for your attorneys?
No.
Did you have an agreement with your attorneys that they would volunteer their services?
No.
And have you personally obligated yourself to pay for your attorneys?
Yes.
Now, Mr. Dunn asked you questions about, again, your defense against these ethics violations being in aid of your campaign. Did you ask that those ethics violations be brought against, or those ethics complaints be brought against you?
No, I did not.
Okay, would you have chosen not to have those ethics allegations brought against you?
Yes.
Okay. Now, you did donate $500 to your campaign in the seed money part of the campaign, correct?
Yes.
Okay. You chose to do that, right?
Yes.
Okay. And that was to propel your candidacy forward, right?
Yeah, you have kind of like a working capital problem where you have to put some money in so then you can do anything, like turn on your website, things like that.
Okay. No further questions. Thank you, Mayor.
Board.
Any redirect?
Mayor Keller, you used public financing, is that correct?
Yes.
You used the public trust and public monies for the benefit of your campaign.
Well, as per the ordinance allows.
Do you believe that a candidate that uses that public money needs to follow the rules, all of them,
Certainly to the best of their ability.
including the limit on $500 that you can personally contribute to the benefit of your campaign?
Yes.
No other questions for this witness?
All right, and just before we begin, just as a slight reality check here, so far the complainant has used 30 minutes and 45 seconds. The respondents have used 10 minutes and 30 seconds.
Okay.
Floor is still yours, Mr. Dunn.
At this time, we turn to the issue of the attorneys and their rates and fees, and that's what I would ask that Mr. Urias take the stand.
All right, so first of all, Mayor, you may sit down.
Sure.
Thank you very much. All right, so at this point, what I'm going to do is ask for a proffer of what you believe the testimony will show. And at that point, we will, keeping in mind what has already been presented and whether, I'd like you to specifically address how any further testimony will not be cumulative of what we have already heard.
Okay, and I would direct the board's attention to Exhibit 2, which is an affidavit from respondents of Ms. Jennifer Martinez.
And members of the board, we have copies of all of our exhibits. I'm sure you do too, but if we could pass these out, just,
Sure, well, it doesn't hurt.
they're all the ones that you received. You can take a
Well,
everything we previously.
you guys had me require me to give one to you guys. It would have been nice if you guys could have brought me a copy too. And I'm going to direct the board's attention to, thank you, Exhibit 2, again, which is the affidavit. I'm going to direct your attention down to, let's say, page 5 of that exhibit. And I'll wait till everybody can find that before I start.
Just to make sure we are on the, literally the same page, this would be attachment 1, correct?
It's labeled Exhibit 2 on mine, but it's the attachment to that exhibit. Yes, sir.
Well, there are multiple attachments.
So I'm looking at page 5, which is it's got, at the top of it, it says attachment 1, you're right, and then we're at the third page in that document following attachment 1, or the second page of the document, rather. It says at the top line on the left-hand side of the dates, 8/22/2017.
I'm sorry, I'm looking at attachment 1 to exhibit 2. Oh, I see. All right, so
Actually-
you're looking at the first entry for
Right, so,
DHU, 8/22/2017 for 1 hour and 50 minutes, or 1.5.
that's right.
Okay. Is all the board members, are we there? Okay.
Okay, if you'll look on line, the date, it starts with the date 8/23/2017. It has DHU, which I imagine is Mr. Urias, David Urias. This is part of what we'd have him on the stand to confirm. It has 2 hours and a charge of $420, making that an hourly rate of $220 an hour.
I think that's 210.
I'm sorry, you're correct, 210. I can only divide by 3 as most plaintiffs' attorneys. Apologize. I believe that the evidence will show that for Mr. Urias, and we can flip to Ms. Molly Schmidt-Nawara. I'm not as certain what her hourly rate would be, but I imagine that a very simple question to Mr. Urias of what is his normal hourly rate will clear up whether or not this is actually his normal hourly rate. And so I would start with just Mr. Urias, and then if there is further clarification as to Ms. Nawara, we can certainly turn to her next.
Just to make sure I'm understanding, so is the only question that right now you are proposing to ask of, and we'll use Mr. Urias as the scapegoat for right now, is the only question about what is his, for lack of a better word, normal hourly rate as compared to the rate shown on these exhibits?
Yes.
Okay. Let me ask you to hold that. You can stay right there.
Okay.
So, Ms. Schmidt-Nawara and Mr. Urias, with that limitation that that would be the only question, do you still have your objection with regard to the motion to quash?
Yes, we do, Mr. Chair. I don't think there's any reason why we have to testify here. The candidates have already both testified that there was no negotiated discounted rate. Also, I think there needs to be a preliminary showing,
Oh, sorry, Mr.
Chair, I'm sorry.
That's my fault. I should have asked you to come forward.
There needs to be a preliminary showing that even if that happened, even if there was a discounted rate, which there was not, even if there was, does that even lead to a violation of the rules? And it does not. What Mr. Dunn keeps saying is that a discounted rate would be for the benefit of the campaign. Mr. Keller and Mr. Benavides have already testified that this was not for the benefit of their campaign. It cannot be said that to retain an attorney to defend yourself on baseless ethic violations is something that's done for the benefit of the campaign. The rules are quite clear. When it's talking about the benefit of the campaign, it's talking about volunteer services to the campaign during the time that the candidate is running for office and whether or not those are volunteer services. That's not what we're doing here. That's not what happened in this case. They retained us on an hourly rate to defend themselves against these allegations brought to them as individuals. So I'll make 2 points. First of all, the law is quite clear. Attorneys do not and cannot be compelled to testify unless it is absolutely necessary to the litigation and the information cannot be gleaned somewhere else. We already have the testimony of both the candidates. That is where the primary information comes from. To have us come up is simply harassment because there is no valid allegation, there is no evidence that we provided some sort of in-kind contribution. And as I stated, even if there was a reduced rate, even if there was, that is not a violation of the rules because it was not for the benefit of the campaign. Molly and I did not go out and perform legal services during the campaign for the campaign. We didn't put together contracts. We didn't put together agreements between donors and the campaign. That's not the kind of thing that we did. We were representing and we will continue to represent these candidates in front of whatever complaints come before this board at an hourly rate, and that is what we've done. And so I would say that there's no basis in the law for us to have to testify, first of all. And second, even if their allegation was correct, which it is not, it would not be a violation of the rules.
If I might.
Before you go on, Before I make a ruling, let me just ask, do any members of the board have any questions for Mr. Dunn with regard to the proposed question that he wants to ask? And again, the question is not about whether we will allow the witness to answer. Any questions about the argument that, on which it is based? I'm going to shift things out just a little bit out of order because so far the board has not had the opportunity to raise these questions. So do any board members have a question with regard to this?
I do, Mr. Chairman. Mr. Dunn, to be clear, again, it's not allegations about, in-kind, that sort of thing. In my opinion, I think you're trying to determine usual and customary fees for this type of service, provide a value for that service, and if we do rule that it was an in-kind donation, that in-kind was based on the usual and customary value for the services provided. Is that correct?
I believe, yes. If I could, with the clarification. What I'm saying is that if the normal hourly rate is, like I said, $300 an hour, and they only charged, as it appears here for Mr. Urias, $210. And this gets to the larger question, I believe, that the chair was just discussing as to what is the capacity that we're here in today and whether or not they could pay that. Is the benefit to the candidate, or is the benefit of the services to the person? And that's ultimately the question that I think that this board is going to have to come down and decide today. After you've made that decision, the next question is, if it is in the capacity of a candidacy and the law firm gives that $90 an hour discount, is that an in-kind contribution, that $90 per hour that has been given, a contribution in kind that should have been disclosed as part of the campaign finance laws? So you're exactly right. That's exactly the question that I'm driving at. And I think that as far as evidence goes, the board can certainly consider the customary rates for attorneys based upon the testimony of Mr. Urias and Mrs. Molly Schmidt-Nawara, and I think it's an aid of your ultimate decision. If you do decide that this is a candidacy capacity, you need to have the information about how much benefit was they failed to disclose on their campaign disclosures.
Thank you.
Mr. Throckmorton.
Well, I think the uncontroverted evidence that we've heard thus far in this case is that the candidates viewed these as personal expenditures to defend themselves before this board, that those are not campaign expenditures. And if that's the conclusion, then what agreement they had with their lawyers in terms of fees is totally irrelevant. It's not something that needs to be disclosed. And so my view is that the subpoena should be quashed.
Here's how I think I'm going to rule after listening to both sides, and I understand the nature of the board's issues. I'm going to grant the motion to quash. It seems to me that what you're asking us to do is leapfrog over the premise, which is regardless. Let's assume that your premise is correct, that in fact the lawyers normally charge twice what the hourly rate shown in their billable rate is. I'm going to assume that that could be true. If there was a benefit, so far the only testimony that has been presented to the board, the only factual premise that we have, is that benefit inured to the person paying the bill, which so far all we have heard is the candidate. And the bills, I think, speak for themselves, and I don't think there's anything more for the lawyers to add. It's not privileged, but it's certainly cumulative. So what I would prefer at this point is, if you have no other witnesses, I'm going to grant the motion to quash with regard to the testimony of the attorneys. If you have any other witnesses, you'll be allowed to present them. If not, we will shift to the respondent's case in chief. There should be more than enough time for the parties then to have closing argument, and at that time, I'm going to instruct both sides to focus on this issue, which I think really has come down to the key issue based on the evidence, which is assuming that we have heard what we have heard and we have read what we have read, which is that the individual candidates are paying these bills. How does that fact translate into those payments being made for the benefit of the campaign? So that will be my ruling. The witnesses will not be compelled to testify under the subpoena. Do you have any further witnesses to testify before us today?
I don't.
All right. That being said, the complainant will rest and we will shift to the respondent's cases in chief.
Yes, good morning again, Mr. Chair and members of the board. We do not have any witnesses to call. We would like to submit the affidavits that you have as our exhibits, and that will be our case in chief.
All right. So, Mr. Blair, I guess I will ask whether you have any rebuttal testimony or evidence to present.
I don't. I would only respectfully request that the chair address me as Mr. Dunn instead of Mr. Blair.
I'm so sorry. That's completely my fault, and I apologize.
That's okay.
And hopefully that'll be the worst thing you're called today.
It won't be.
That's completely my fault, and I do apologize.
It happens a lot. No,
All
no
right,
problem.
so in that case, there is no further testimony or evidence to present, so we will move into closing arguments. Do either side need any chance to collect your thoughts, or are we ready to proceed?
I'd like to grab a little bit of water if I could.
Fair enough.
5 minutes for that, because I've run out of juice, so.
Please.
Okay.
Oh, okay, I'm sorry, I thought you had some water right there. So we will be in recess then for just a few minutes. 5 minutes. Fair enough. Sorry, misunderstood. All right, we're ready to get going. So we are now at the point of the hearing for closing arguments for each side. The complainant has a total of 25 minutes remaining out of their allotted time, and the respondents have 48 minutes remaining out of their allotted time.
Thank you, Mr. Chair. And I will do everything I can to stay well short of the 25 minutes. But this is a very important point of contention. And I'm going to speak to you now more as a citizen of Albuquerque than as an attorney. And what I expect out of my government, what we should expect out of our government in this city. I will tell you that you've heard a lot of conversations about this idea that this is a personal capacity. That gives me a whole lot of pause as a citizen. For somebody that's going to take almost $400,000 of taxpayer money in order to run for a public service office in this city. That carries with it, and should carry with it, an enormous amount of responsibility to follow the rules, to not try to find ways to wiggle around them. You've heard from Mayor Keller about one of the complaints that I had early on, and I know this board has ruled on the in-kind donations issue previously and found that he didn't have any intent to do that. Now, I have an opinion as a lawyer that certainly differs from that. And since he raised it, I'd like to address it. When you tell somebody, do this, donate here, and that won't cause any sort of issues for campaign finance, that's inducement. That's telling somebody this is okay to do it this way. That's inducement. Criminal fraud and inducement requires that kind of intent, telling somebody to do that. One of the other things he raised was conspiracy. I think there's plenty of evidence that his campaign staff was aware of this, and this is a discussion they had about going about doing this. So from my book, we've got 2 out of the 3 right there. Those are felonies at the amounts that we're talking about. When you get down to the fact that if you take that and you say, I'm going to conceal the source of this money, and I'm going to call it something else, that is the definition of money laundering. It absolutely is. And my concern for today's hearing is the same concern. Now, I wasn't allowed to ask Mr. Urias and Molly Schmidt-Nawara what their typical hourly rates are, but I had impeachment evidence here that would show that what they charged in the evidence in front of this board is not what they charge now. I have a declaration from Mr. John W. Boyd, which he discusses the hourly rates of Mr. Urias. And in 2013, it was more than what's on this invoice. Now, why did they do that? What's the benefit? They just like Mayor Keller as a nice guy. Great, I do too. But he's not here because we don't think he's not a nice guy. It's not about his personal capacity and whether or not he's a nice guy. He's got a great smile, no doubt about it. But we are here because he's not following the election code when he takes public financing. When he takes that public money to run for a public office, he's limited to contributing for the benefit of his campaign to $500. He spends $30,000 on lawyers to help him defend against his violations of campaign finance. That's to the benefit of his candidacy, not to him as a nice guy. And if they gave him a nice guy discount, great. I would have loved to have been able to ask them why there was a discount, because there was. That's an in-kind donation. For whatever the reason might have been, whether it's the nice guy discount or, hey, we'd like for you to be mayor, so we'll help you out discount. No matter what it was, there was a discount and a benefit that that campaign received when it took public financing that he is not being held to account for. And the job of this board is to hold people to follow the rules. The rules say $500 is the most he can give in his personal capacity to his campaign. If either of these two individuals turn around and writes a check, wherever the money may have come from, whatever laundering scheme may have come up to and enable them to have that kind of financial wherewithal to write a check for $30,000 or $43,000 or however much it actually ended up being, no matter what, that money was to the benefit of the campaign, not to them personally. Now, they may benefit personally by not being held in violation of these rules and not have to pay a fine. But what the taxpayers are owed is those amounts back into the public coffers. That's what your rules say. The rules say that if you go over the average, over the amount that you can have in in-kind contributions, or over the amount in seed money, that you're supposed to pay that overage back. That's in your rules. That's why we're here. If they want to do that, that's fine, but the money needs to be paid back to the taxpayers, and this board owes an obligation to the taxpayers to make sure that those rules are followed, and if there is an overage, that money is returned to the public coffers. That's what this is about. I'll reserve the remainder of my time.
Well, before you sit down, do the board members have any questions for complainant? I have one. In opening statement, counsel for the respondent pointed the board to our rules and regulations, specifically section 6I11. Can you comment on the respondent's view of the significance of that provision to our consideration of the issue you've presented?
I'd ask the chair's indulgence if you could direct me to the language from 6I. I don't have it in front of me, so in order to speak intelligently, I'd probably need to hear it.
Well, sure. It's section 6I, which covers fines, subsection 11, which is titled Limitation on Source of Funds to Pay Fines, and the section reads, quote, a candidate, the chairperson of the Measure Finance Committee, or any other obligated person subject to a fine pursuant to the election code and these rules and regulations shall not use contributions received by such candidate or the Measure Finance Committee to make payment of any fine assessed under the election code or these rules and regulations. Payment of fines may not be included as an expenditure for purposes of Election Code Section 4F, the calculation of unexpended contributions. So can you comment or respond to the complainant's argument regarding this specific section of our rules?
As to that specific section of your rules, the rules are very clean and very clear, and it's absolutely true. If you do assess a fine to Mayor Keller and to Mr. Benavides for failure to make a disclosure or to violate these rules, that's supposed to come out of their personal pockets. That's clear, I get that. That's absolutely what the rules say. My argument is that also contained in your rules in section 6 of the election code is the idea that a candidate or a campaign that receives contributions in excess of the limits, which my understanding is that the limit is $38,000 in in-kind contributions that Mayor Keller could have received, My understanding is that he's likely hit that number already. Anything over that, whether it's in-kind donations at a discounted hourly rate by his attorneys, or it's him taking the money out of his pocket in excess of $500 to pay for that, that money ultimately needs to be paid back to the public coffers because that's an overage of the allowable limits. And that's where we are. We're trying to figure out whether or not there's an overage of the allowable limits. And if I'd been allowed to take the testimony of Mr. Urias, I'm pretty sure we could have done the calculations to see whether or not even just the in-kind donations attributable to a discounted rate, an hourly rate for attorneys, would probably put both of these candidates over the allowable amount of in-kind contributions that they can receive.
Any additional questions? Thank you very much. For respondents.
Thank you, Mr. Chair and members of the board. I'm going to focus on what the board, I think, has drilled down to as being the essential question as to whether these candidates have obligated themselves to pay these attorneys' fees as individuals or for the benefit of their campaign. And I think it's clear that the complainant's argument that these monies that they've obligated themselves to pay are not for the benefit of the campaign. And I would submit to the board that if the board were to accept that argument, then literally anything a candidate does, pays his mortgage, pays for child care, pays for health care, anything he or she does that helps sustain him or herself could be theoretically attributed to contributing to the campaign, to his or her campaign. Mr. Keller couldn't do what he does, or couldn't have done what he did as a candidate without having the assistance of childcare because he has 2 young children. Same with Mr. Benavides. That doesn't make any sense, and that really sort of spins the meaning of these rules and regulations, these ethical rules, to a universe that is completely unfounded and baseless at this point. Moreover, there is a good faith basis to read into this board's rules our interpretation of this. And again, I would point to section 611, I-11, the limitation on the source of funds to pay fines. This clearly indicates that when these complaints are brought against an individual, then that individual, they're representing themselves, they're being represented, they are obligated to pay as an individual, as a person, not as a campaign. Now, Mr. Urias and I have had the privilege of representing Mayor Keller and Mr. Benavides, but I know that these men, I'm sure these men wish that they didn't need to retain us. They didn't bring these complaints voluntarily against themselves. Oh, excuse me. These complaints were brought against them. And once these complaints were brought against them, they had to defend themselves. And even if they were not candidates, they would still have to defend themselves against this board. This board has continuing jurisdiction against individuals, even if they lose elections. That's true. Look at Mr. Benavides. Mr. Benavides lost in the general election. Nonetheless, there is still a pending appeal against him in the district court brought by Mr. Rogers. This board had the jurisdiction to hear this complaint. So clearly this argument that the attorney's fees are being used, that attorneys are being used purely for, or even largely for the benefit of a candidacy or a campaign, just isn't true, isn't borne out by the facts, isn't borne out by the rules and regulations, and certainly isn't borne out by this board's jurisdiction. So we would ask this board to dismiss this complaint in its entirety. First, the original bases for the complaint have been proven to be false. No public monies were paid to finance the attorneys, and the attorneys did not volunteer their services, necessitating a reporting of in-kind donations. And as was raised today, we would ask the board to dismiss the complaint on the threshold matter as to whether these fees are going to be paid for the benefit of a campaign, because they simply are not. They are these individuals, as individuals, have obligated themselves to pay the attorneys as individuals, and thus there is no ethical violation.
Are there any questions for the respondents? Thank you very much.
Thank you.
Any rebuttal?
The idea that you can equate childcare to attorney's fees in an election campaign finance hearing is not going to pass the smell test with the general public. Certainly won't pass the laugh test with most people. The idea that when you avail yourself of an election, when you decide to become a candidate, that you're not, that your personal capacity is all that you exist in, there's no premise in the law for that. That's not why we're here in front of this board. This board has no jurisdiction over the personal matters of any candidate. This board has jurisdiction over election matters and adherence to the rules. So the idea that attorneys that are showing up here in front of this board are showing up here in a personal capacity, I'd hate to have to be the one to make that argument to the public. I'm glad I'm not. I really don't think this board would like to be subjected to that kind of a thought process either from the public. But here's the difference. When you have a candidate that avails themselves of public financing, they are signing a contract with the taxpayers to follow the rules, to be upright, and to not use other money for the benefit of their campaigns, solely to use that. That's the impetus behind public financing. If Mayor Keller wanted to do this, he could have foregone public financing. He could have made the personal decision to say, I'm going to personally do this, and I'm going to use public financing. But he didn't. His personal stance went out the window the moment that he said, I'm going to take public financing. I'm going to be a publicly financed candidate. He puts on the public finance hat in order to spend that public money. He's subjected to the public rules, and the rules are clear. The most that he can personally contribute is $500. And again, to try to equate that his mortgage or childcare has anything to do with a public financing question in front of this board that he would retain attorneys to help him with is flat laughable. This board owes the public the same duty of trust that Mayor Keller and Mr. Benavides owed when they agreed to take public financing. He is supposed to follow the rules, and this board should require that he follow the rules to the full extent of the rules. Thank you.
All right, I'd like to thank all counsel for their presentations. At this point, do we have a motion?
Mr. Chairman, I move that the board go into closed session pursuant to New Mexico statute annotated 1978 10-15-1, Section 8, Part 3, in order to deliberate the evidence received at the hearing held before the board in case number 11-2017.
Is there a second to that motion? I'll second the motion. Motion's been seconded. All those in favor of the motion to go into closed session, please indicate by saying aye. Aye. Are there any opposed? We are in closed session. All right, for the record, the board is back in open session at 11:02 a.m. The board had a closed session pursuant to New Mexico statute annotated 1978, section 10-15-1-H3, to deliberate on the evidence received at the hearing before the board in Board of Ethics case number 11-2017. No action was taken and no votes were made. At this time, is there a motion from the board?
Mr. Chairman, I move that the board find in favor of the respondents, Keller and Benavides, on the claims alleged in the complaint, and that we issue a written decision explaining our rationale for this finding in accordance with our rules.
Is there a second to that motion?
I'll second that motion.
Okay. Is there any discussion? All those in favor of the motion as stated indicate by saying aye.
Aye.
Are there any opposed? Minutes should reflect that the finding was unanimous. There being no further issues on today's agenda, is there a motion to adjourn?
Mr. Chairman, I make a motion to adjourn.
Is there a second?
I'll say.
All those in favor of adjourning, please indicate by saying aye.
Aye.
Okay. We are adjourned.